Ladies and gentlemen, order in the court. I know that's corny. I couldn't resist it. I said it before the justice came in, though, because I didn't want to embarrass myself. However, speaking of the justice, ladies and gentlemen, please welcome Stephen Breyer, Justice of the United States Supreme Court, accompanied by Dr. Tim Naftali of the Richard Nixon Presidential Library and Museum. Thank you, sir, for honoring us with your presence tonight. We are indeed honored and delighted that you're here and that you have brought us your book to have you sign and to read and to learn from about our democracy. And there's good news and there's bad news. The good news is we had a raffle for the book. The bad news is only one of you is going to win it. And here, in my formerly nicotine-stained hands, is the winning number. And the winning number is, bring out your raffle tickets. Gee, I don't know if I got mine. Honey, where is it? Look under the chair. It's got to be here somewhere. All right, are you ready? The winning number is, and if you want it, we're going to check, of course. You stand up, yell and scream, and we'll bring the book to you, okay? Our book carrier is right here, and the winning number is 743-008. Won by Justice Breyer. Good Lord. All right. Whoever won it, please stand. Thank you. Tony, check the number. Check the number. Good stuff. Thank you all for buying the ticket. You're helping the Dawson Guild, so thank you. I want to introduce a couple of people. We're delighted to have the Dean of the Chapman University School of Law, former U.S. Congressman Dean Tom Campbell. Thank you, Tom. Equally honored to have the Dean of the USC School of Law, Robert Rasmussen. Thank you for coming. Plus, we have Supervising Judge of the North Justice Center of the Superior Court, Sheila Hansen. Sheila. Thank you for coming. Thanks all of you. My job here is to give away the free book and to remind you that we have them in our gift shop. The Justice has agreed to extend the session tonight a bit and sign them. So immediately afterwards, he will disappear and reappear at the book signing, which is in the lobby as you go out to the right. If you don't already have a book, and I see that a lot of you do, you can get that in the gift shop. And we'll move the book signing very efficiently so you won't be here too late, and he'll sign your book, and that is indeed a treasure. My job, other than that, is to introduce my counterpart on the federal side, the distinguished director of the Richard Nixon Presidential Library and Museum, my colleague, who we are co-hosting, as you can see tonight by these two logos. We are co-hosting the appearance of the Justice here tonight, and we do that cheerfully. And it is my pleasure to introduce Dr. Tim Naftali.
Thank you, Sandy. Thank you, Sandy, and thank you to our colleagues at the Nixon Foundation for cooperating with us on tonight's event. Welcome to the Richard Nixon Presidential Library and Museum. And welcome home, Justice Breyer. The Justice is a native Californian, born in San Francisco and a graduate of Stanford. In 1994, President Bill Clinton nominated Stephen Breyer, then a judge on the United States Court of Appeals, to replace Harry Blackmun on the Supreme Court. Especially resident here, Justice Blackmun had been one of President Nixon's appointments to the High Court. Tonight's event is a reminder that Justice Breyer remains committed to being a teacher in addition to his august duties as an Associate Justice of the Supreme Court. Starting in 1967 as Professor Breyer, the Justice taught many classes at the Harvard Law School and Harvard's John F. Kennedy School of Government. Making Our Democracy Work is the second book that the Justice has written while serving on the court. The first, Active Liberty, which appeared in 2005, was an elegant guide to the Justice's views on the role of the judiciary and legal theory in our society. At the Nixon Library, we are committed to reminding students and other visitors that there are 3 branches of government, and that each plays a role in shaping the direction that we take as a nation. We are honored to have such a great citizen of our country and representative of the federal government at the Nixon Library, and are equally fortunate to be in the presence of such an accomplished teacher and thinker. Again, welcome home, Justice Breyer. Thank you for gracing us with your presence.
Thank you. Very nice, very nice. I'm glad you won that copy of the book. I mean, when I was growing up, you know, my father, when he was really angry at me, would say, "You take the prize." And I never knew I would write something that was the prize. I mean, it's very good. And we did used to come down here a lot when my uncle lived in Redlands, and every summer we would drive down to Redlands, and at that point I think there was orange groves. That's what was here. It was orange groves. I think there was a train that they used to say went to Anaheim, Azusa, and Cucamonga. And I've always wanted to take that train, and there we know it's disappeared. But I'm glad to be here because this is history. And you look around this very lovely building in the place, and you see history. And I think it's such a good thing to be able to show those generations what happened, what the institution is, what people do. And indeed, that's really partly, I mean, that's the main reason I wrote this book, because we live in a time when I think an awful lot of people are pretty cynical about the government, and particularly younger people. And maybe some of that cynicism is justified, but if, in fact, people are too cynical, they won't have a government. And so I think, look, what can I do about that? And I think in the same way I think about everybody, I think almost everyone in public life thinks this. Explain to people what you do. Tell them about it. They may become cynical, fine, or not. But at least let them know. And of course, I think that the more you know, I mean, I know the court. That's where I work. So I thought my contribution here can be to try to explain the court as I see it. I mean, I want people to read this who are not lawyers and they're not judges. And when I think of an audience, I think of an intelligent man or woman who's busy. That's the first thing. Imagine a woman going in the supermarket. And what is she going into the supermarket? She has to get dinner. She has a job. She has several children. There are bills coming in every single month. They have to be paid, and there's lots to worry about. And one thing she doesn't necessarily have time for is hearing me talk about the court. Well, but I want to talk to her. And if I could get half an hour or so of her time, I want to talk to her because I want to tell her why she might think it's worthwhile giving the court her support, not in individual decisions, but as an institution. And as you'll see, that's pretty hard to ask for that support. Why? Because we're going to decide a lot of things that are unpopular. And we're also often wrong. I won't say often, let me not overstate that, but we can be wrong. We're human beings. And we have dissents, and I write a few of them. And so, but everyone understands that. And moreover, we are unelected people, 9 of us, and this is a democracy. So that's what I want her or him to think about. Why should 9 unelected people be able to make decisions, maybe fewer than you think, but make decisions that will affect the lives of many, many Americans. Why, when we're not elected? What's the point of this? How could it have happened? And I've tried to figure out a way to organize this so that the question becomes gripping, and what I've tried to do is I've asked two basic questions. Now, I'll tell you the first question. The first question arises out of a circumstance. The circumstance is you're back at the time of the founders, and they're trying to decide, do we create a Supreme Court which probably, and they thought the answer was yes, they will, have the power to overturn a law of Congress. Why? Well, if you have the chance, the best exposition I found is Alexander Hamilton, number 78. And I paraphrase that a little bit, but the way I paraphrase it, and it's truth to what I say, but he doesn't quite put it this way, is Alexander Hamilton and James Madison and the others have written a pretty good document. Here it is. And indeed, the more you work with it, the more you think, my God, it's an amazing document. But it gives us some outlines of boundaries of how other people in the government should behave, what goes beyond the boundary. It creates a democracy, it protects basic rights, but these are boundaries. Now, how do we keep all those people who are working in governments within the boundaries? I mean, somebody better have the power to say when government officials have gone beyond the boundaries. Why? Why should someone have that power? Well, he's thinking, this is a beautiful document. But if nobody has that power, if nobody has the power to say when this has gone too far, well, we can hang it up in the museum. We'll put it in the National Gallery. No, actually, he didn't say that because there was no National Gallery at the time. But you understand what he's thinking. I mean, this is meant to be a practical document that in fact will work in practice. And he's thinking that as part of that, somebody better have the authority to say when people overstep the boundaries. Well, who should it be? I'm paraphrasing. He says, the president? We give this power to the president, he'll become a tyrant. He'll just say everything he does is fine. No, not the president. Congress. Congress, after all, are the elected officials. Why shouldn't they have the power? And what he says is, well, in effect, he says, look, this document gives exactly the same rights to the least popular person in the United States as to the most popular. And it won't be a problem with Congress if it's popular. But look, Congress are experts on popularity. I'll tell you, if there's one thing they know, it's popularity. And believe me, they wouldn't be there if they didn't. But will they, in fact, when they've just passed a law, and that law is popular, then say, no, it's unconstitutional, when saying that is very unpopular? And Hamilton, in effect, says, no, I don't think they will. I mean, we better not give them the power. Ah, but here we have, over here, some rather gray people called judges, sort of like bureaucrats. Nobody really knows them. Nobody's heard of them. They don't necessarily like them. And moreover, look, they know something about law, and this is sort of a legal job anyway. And more importantly, they don't have the power of the purse, and they don't have the power of the sword. They're weak, so they won't go too far. Now, they're not going to be perfect, he says, but that's the best place to put it. Fabulous. And now this is the question he did not answer. He did not answer this question. If they're so anonymous, if they have no purse, if they have no sword, if a significant part of their job is to make decisions that will be unpopular, why in heaven's name will anyone do what they say? I mean, that's Shakespeare's question in Henry IV. Owen Glendower comes in, he's a Welshman, and you know all the Welshmen in Shakespeare are mystics. So Owen Glendower says, I can summon spirits from the vasty deep. And Hotspur, who is your practical Englishman, says, well, so can I. So can any man. But will they come when you do call for them? Yeah, that's the problem. That's the point. And I get that question a lot. I get that question in various forms. I get that question not just from Americans, but from Latin American judges or from Asian judges, or I had in my office not too long ago a woman who was president of the Supreme Court of Ghana, the Chief Justice. And she's trying with a lot of others to assure democracy and certain protection of human rights. And she says, why do they do what you say? I said, well, it's a fabulous document. And it really has worked. But I can't answer that in a single question. I have to tell you a little bit of history. And so what's the history that I tell her? And I've said this a lot, but that's what's in the first part of this anyway. I say, when John Marshall, in Marbury versus Madison, which most of us know, said the court has the power to overturn a law of Congress. First, he didn't make that up. That was among the founders, they probably the majority, vast majority thought that. And, but will Jefferson do it? Will Jefferson follow our rule? And I'll take a long story short. He said we have the power to declare a law of Congress unconstitutional, but through a very clever device. He says, and Jefferson wins. Now, Jefferson was prepared to ignore what Marshall was going to say. He thought he'd decide the case against him, and Jefferson's sitting there just prepared to ignore it. And what Marshall does is he takes the power Jefferson didn't want them to have, and he makes Jefferson win the case, and the result is Jefferson is left sputtering. And read some of his letters from that time. They sound as if they're sputtering. But you see, the court is worried. Will people, in fact, do what they say when they find something unconstitutional or illegal? They had cause to worry. Only a couple of decades later, a case came up involving the Cherokee Indians. Now, the Cherokee Indians owned northern Georgia. There were treaties that said northern Georgia belongs to the Cherokees. And the Cherokees had given up, that group had, hunting and fishing. They were farmers. They had an alphabet. They had a constitution. They had a great chief, Chief Ross. And they had one more thing, which really was unfortunate for them. They found gold on their land. Now, the Georgians thought, gold? Why should the Indians have the gold? Why shouldn't we? And they just marched in effectively and took it over. Well, the Indian tribe, the Cherokees, were very civilized, and indeed they did what any civilized person would do. They hired a lawyer. The lawyer then brought their case, and it was a very complicated, he was a great lawyer, Willard Wirtz, he was Attorney General, he was one of the great lawyers of his day, and he, in fact, eventually got his case to the Supreme Court, and the Supreme Court said what I've suggested, of course the Cherokees own this land. Of course it doesn't belong to the Georgians. And you may have heard of this case, even though some of you don't know you've heard of it, because it would be more familiar with you what the president, Andrew Jackson, supposedly said about that case. Andrew Jackson said about that case, John Marshall has made his decision, now let him enforce it. Right. And Andrew Jackson sent troops to northern Georgia. But they did not go to enforce the rule of the Supreme Court. What they did was they went to evict the Indians. And they did. And the Indians traveled the Trail of Tears to Oklahoma. It's called the Trail of Tears because so many died on the way. And they went to Oklahoma, and their descendants are there to this day. So we go to the 1830s, it doesn't look as if things are going to be so wonderful for unpopular decisions in the Supreme Court. Now, I'll skip a lot of history because I want to go up to a case which I find very interesting and has always meant a lot to me, and I think represents a step towards an evolution. And that is the case of Cooper versus Aaron, which some of you but not all will have heard of. And Cooper versus Aaron arose after Brown versus Board of Education. Of course, Brown versus Board of Education looked at the document. It says, no state will deprive any person of equal protection of the law. And they looked around, and at that time in the South, you'd have to have been blind not to see what was going on, that their racial segregation was depriving black people of equal protection of the law. And what the Supreme Court said in Brown was, this runs counter to the 14th Amendment. You cannot have segregated schools. You better integrate. Well, that was 1954. What happened in 1955? You got it. Nothing. I mean, very little, almost nothing. So what happened in 1956? Yeah, you're right again. Next to nothing. And then in early 57, a judge in Little Rock said, we're going to have Central High School integrated. The NAACP had brought the case, and the judge, the federal judge, ordered the school board, ordered the state, adopt the plan, and the plan was going to have the Little Rock 9 African-American children who would enter that school in September. Now, they were pretty brave, and the NAACP had made a big effort to find these 9 children who were willing to undergo that, and they did, and they were brave. And in the beginning of September, some of us can remember that beginning of that September. There were White Citizens Council members, hundreds of whom had driven to Little Rock. And Governor Faubus, who had started out as a racial moderate, was moving as fast as anyone can towards becoming an absolute segregationist. And the governor of Georgia, I think it was Georgia, did not help that summer when he came to Arkansas and said, I don't see why the people of Arkansas have to integrate because we don't do that in Georgia. Very helpful. Thank you for that remark. The governor said, no, they're not coming in. He said, you can have as many judges as you want, but I have the state militia. And he told the state militia to keep the children out, and in that early first week of September, when they tried to go into the school, they were turned away by these crowds, as well as by the militia. And they reconnoitered, and they were supposed to not go to school the next day so they could figure out what to do and go back to the judge and so forth. But that next day, one of them didn't get the word about not going, and that was Elizabeth Eckford. And she went to that school and was turned away. And as she walked back towards the bus stop, a photographer took her picture. And that picture shows this very dignified young woman. And behind her is a white woman whose face is enraged. And that picture went her, Hazel Bryant. She later, by the way, said she was sorry. Well, okay. But that picture went around the world. It went around the world. And it said to the world, this is the United States of America in 1957. Not happy. Well, Brooks Hayes, who was the congressman from Little Rock, called President Eisenhower and arranged a meeting between Governor Faubus and the president at the summer White House, which was in Newport. And Governor Faubus went up there and he met with the president. And later he said, the president dressed me down like a general dresses down a private. And he told the president, don't worry, I'll integrate the school. And he walked out of the room and told the press the opposite. Yeah. So Eisenhower was not happy. And he had to figure out what to do. And over the next few days, he got advice. I mean, Jimmy Burns, again, some of you remember. Jimmy Burns was a member of the Supreme Court. He had resigned from the court during World War II so he could run the domestic part of our mobilization effort. And he was then governor of South Carolina and a moderate on race at that time. And he saw President Eisenhower and he said, Mr. President, if you send troops to Arkansas, you'd better be prepared to reoccupy the entire South. You better be prepared for a second Reconstruction. And at best what will happen is they'll close the schools and nobody will be educated. Well, at the same time, Eisenhower's Attorney General, Brownell, was telling him, you've got to do something about this. You cannot just let this happen. And Eisenhower took that advice. And what he did within a very few days is he got on television, and it wasn't television, I guess it was radio. That's a good question then. 57? Well, he'll know. He's a historian. You know, he announced to the public that he was going to send the troops. And what he did is he picked the 101st Airborne Now, every American, or just about, in 1957 knew who the 101st Airborne was. The 101st Airborne had parachuted into Normandy, and a lot of them got stuck on the steeples, and they were shot down. And the 101st Airborne were heroes of the Battle of the Bulge. And Eisenhower deliberately picked those paratroopers. He put 1,000 on the airplanes. They flew them into Little Rock, and the next day they walked those black children into that white school. Pictures were taken. And that picture, that much better picture, went around the world. All right, that was a great day. It was a great day for the rule of law. It was a great day for the cause of equality in America. It was a great day for the United States of America. I wish I could end the story there. I can't. See, what happened next? Well, you can read, and I hope you do sometime, about what life was not pleasant for those 9 children in that school. And they were there, but they couldn't stay forever. The paratroopers couldn't, and they left. And once they left, well, a segregationist school board was elected in Little Rock, and they said, we don't want to do this anymore. We've had enough of this. It's too confusing, too complicated for everyone. And they went back to court and they said, let's stop for a while. We'll continue the integration a few years from now, but let's end it at the moment because it's too complicated and too much trouble, blah, blah, blah. Well, that's the case that went through the courts and went up to the Supreme Court. And the Supreme Court said, no, you keep going. You integrate that school. Now, do it. And we mean it. And all of us mean it. And they all signed the opinion, which rarely happens, if ever. I mean, it was not just that there was no dissent. It didn't say, as it normally said, so-and-so announces for the court. It's every one of them, Black, Douglas, Frankfurter, every single one. Warren was, of course, the chief. But I'm not going to go through the names. The point is they all signed it. Well, wait. There's still 9 judges. I mean, you could have had 9. You could have had 900. You could have had 9,000. And the day after that opinion came, not the day after the decision was made, in the summer of 1958, late summer, the next day, Governor Faubus closed the schools. And that school stayed closed, Little Rock High, Central High, for almost a year. It was closed. And read the story of what happened, white and black. It was tough, and a lot of people's lives were ruined as a result of that. But you see, why do I say that? How do I look at it? I'm a judge. And of course, I think it was fabulous that they sent those airplanes. And I know that soon thereafter, lots of things that we know occurred. There were the Freedom Riders, there was Martin Luther King, there was the bus boycott. There were all kinds of things that went on. And I hope you will see that I do think that sending those 1,000 paratroopers was a key moment. Of course it required lots else besides, small perhaps in the total picture, but an important part of the picture, and an important part for the rule of law. So when a few years ago, we had, the State Department called up and said, we have a Russian paratroop general here, and he was in charge of the missiles, and he used to point them all at the United States, and now they're pointed somewhere else, and we should be nice to this man. Good point. And so we'd like him to see the court, and I took him around. And he was asking what cases are particularly important for you. What do you think in the court's history? And I told him about Cooper versus Aaron, because that means something to me in terms of the rule of law. And I said, well, it shows the paratroopers and the judges must be friends. And there is something to that. It's a long, complicated story. About what? Well, you now think of the case of the Supreme Court that you like the least. That might be tough because there might be quite a few. But nonetheless, think of one you really don't like. Is it abortion? Is it a ruling on prayer in schools? What about Bush v. Gore? That's nicely unpopular with about half the country. I dissented in Bush versus Gore. I thought the court shouldn't have gotten into this. So I think it was wrong. All right? Now, one of the most interesting remarks I've heard about it was made by the majority leader, Harry Reid. He said in our court, speaking at a dinner one night, and he said one of the most remarkable things about that case, he said, is something that's rarely remarked. And that's this, that although half the country, at least, it was very unpopular, and might have been wrong. I suspect he agrees with me that it was wrong. But despite that, people did follow it. There were no riots. There were no stones. There were no guns. They didn't kill each other. And they didn't hurt each other. And my God, he said, that's remarkable. And that is a treasure for this country. Now, I promise you, a lot of audiences where I tell this story, and I know perfectly well when I say there were no riots and people weren't hurt, what their thinking is, and too bad there weren't some. Okay? So when I know what they're thinking, or at least some of them, so I say, I know that's what some of you are thinking. But before you make up your mind about that point definitely, I would like you to turn on the television set, and I would like you to look at what happens in countries where they decide to resolve their differences through guns and stones and sticks and whatever, instead of in a courtroom under law. And that's why, I hope I persuade a few, that's why Harry Reid said, this is a treasure. And I see that treasure in front of me every day. And I want to get that point across, because I know we can be wrong. I've made that point. But still, look at how we're resolving our differences. And of course, what that tells me is really this is addressed to you, not just to judges, teachers, parents. It's really a long commercial message. And the commercial message is, please teach the next generation, the generation after that, something about our government. We used to have, I remember going up to Sacramento when I was in, it was called 12th grade civics. And at Lowell High School, the thing you really looked forward to was going up to Sacramento, I think because there was a Dairy Queen where we stopped on the way. But nonetheless, we got up there. We got up there and looked at the governor's office and saw the legislature, and we were taught something about it. And I think too often in this country now, there are just too few classes in what I call 12th grade civics. I don't mind, teach it in the 4th grade, teach it in the 6th. But unless people understand what they have, it'll be lost in a generation or two. So I say that part of what I'm saying is really addressed to everybody, to the teachers, to the school boards, to the legislators, whoever. But I don't want to let the court off the hook. And there's a second part of this where I try to get to another question, because I want to show people how at least I see what we do. And that second question is a little more technical, but it starts out non-technical. It starts out by saying this. Look, we're unanimous in our decisions close to 40% of the time. Yeah, I know that comes as a surprise. You wouldn't know that from reading the paper. But we're 5-4 about 20 to 25%. And it's not the same 5 and same 4. But still, there are a lot of controversial issues. And this document doesn't really resolve every question. Try the freedom of speech. It doesn't say exactly what the boundaries are of the freedom of speech. Or try liberty in the 14th Amendment. It doesn't say quite. And the cases which are the most controversial about those border words are going to come to us. And it's hardly surprising that we don't always agree. They're hard questions with a lot to be said on both sides. So I want to spend a little time, which I won't this evening, but it's in the book, to try to have half of the thing. But how should we decide those questions? How should we decide? Well, given the idea of it's important to have public following, what we do, you might think, and if I ask this question, many of you will think, and I won't look, you don't have to hold up your head. How do we decide those questions? And I think in most places, what people will say, I know what it is. They'll say it to themselves because they don't want to be rude. But they'll say, politics. That's what it is. Political wind. We'll see which way it's blowing. I say, no, that's not right. They say, of course you would say that. I say, no, it really isn't right. I mean, suppose it were politics. Then Hamilton was wrong. Judges are terrible politicians. That's why I wanted to put in something about the Dred Scott decision, which Roger Taney may have decided because he hoped it would avoid the Civil War. Terrible decision that a person who's a descendant of a slave is not a citizen, can't be a person, etc., etc. And he might have thought that he was going to avoid the Civil War. Well, Abraham Lincoln read the dissent. And he put at the Cooper Union speech, he put a lot of the dissent into that, and it really helped him in the Republican Party, and it helped the Republican Party lean in the direction against slavery, and pretty soon we had the Civil War. So if it was Taney's object to stop it, he didn't succeed, he was a bad politician, and that's true of most judges. Don't give us a political job. We'll muck it up, all right? And it's not supposed to be, and it isn't. So maybe I've said you enough to show you why that's an unacceptable solution. Well, what about history? You say, yeah, you've heard enough about that, originalism, to know there are some judges who in totally good faith, and there's a lot to be said for their position, think you can find the answer to these questions in history. And what we'll do is look back and see what people thought in the 18th century, at the end of that century, and then that'll help us decide these difficult things. In fact, probably decide it, and I say, Nino Scalia and I, who are good friends, we debate this quite a lot, and so we've done it in public. And he'll make this point, or something like it, and I'll say, George Washington didn't know about the internet. And he'll say, oh, yeah, I didn't know that, actually. You didn't have to tell me that. I mean, we have case after case, question after question, where I think what the job is applying a value that's in that document to changed circumstances. I don't think the originalism can work, but he'll say to me, and I'll say, I'm not a historian, have 9 historians if you want. I mean, you're going to do that. It just doesn't give you an answer in too many cases, in my opinion. And I don't think, and he says, well, but I want to control the subjective influence of the judge, I said, I think you can do that without that. He says, no. He says, let me tell you a story. This is Justice Scalia. He tells the story. It's a good story. He says, 2 campers are camping. One's putting on his running shoes. Well, says the other, why are you doing that? Because there's a bear, says the first. A bear? He says, you can't outrun a bear. He says, yeah, but I can outrun you. All right, and that's his point. He's not going to say this is perfect, the originalism, but he's saying let's lean in that direction, does more than you think, and it controls it so. I said, well, I don't think that is the right answer, and I try to explain that, but I said, well, what is? I said, the problem is the judges who I admire very much, and most of us do, Learned Hand, Brandeis, Holmes, Cardozo, Frankfurter, all right? That they did have an approach, but it can't be reduced to a single word. Okay, what is it? I say, I found a good description in Gordon Wood's book about the 18th century Connecticut, where he talks about a judge who said the American system of deciding these difficult, open questions, he says, is based on prudence and pragmatism, reasonableness and utility. I like those 4 words, but they're still bumper stickers. I mean, I think we can go further than that. I can say, well, look, we're going to take values, and the values don't change. The values are right there in this document, and those values are the same values today, just about, that they were in the 18th century, and we're going to apply them to ever-changing conditions. All right? And I'm going to say we have to know that this document's designed to have a government that works in all its parts. So the court isn't there just to check other branches. It's also there to produce a system that will work for other branches, all right? In other words, pay attention to the practical consequences and the ability of other branches to do their job. And also, I do use the word pragmatism, because so often the cases of our court are not right versus wrong. They are right versus right. I mean, First Amendment expression, valuable. Against privacy, search and seizure, valuable. And the question will be how to balance those 2 things. And I think pragmatism plays a role there. But I'm not going to persuade anybody unless I use examples, and so I'm afraid I can only give you 1. Well, but you can read one. But the one I want to give is a really tough one, really tough. And it's the relationship between the court and the President of the United States. Could not be more important. In time of security risk or war. I mean, look, this document gives to the President, and certainly to the President together with Congress, the power to protect us in times of national emergency where there is dangerous security risk. And Jackson said, well known, this document is not a suicide pact. Absolutely right. But at the same time, there is a long list of basic fundamental rights. And there, the court is given power to protect those unpopular individuals. So what do we do when those two things conflict? And my goodness, that's turned out to be difficult in the course of history. I can remember my mother driving down by Can Fran racetrack in San Francisco. It was Santa Anita here, and what those tracks were used for in the January, February, March of 1942, there were 70,000 American citizens brought there, American citizens of Japanese origin. They were brought to those places, and they were sent to camps in the Intermountain area and inside Eastern California. Yeah, against their will, against their will. Why? Well, people were frightened of invasion. I can remember that too. I can remember the curtains coming down, those blackout curtains. And they were afraid. And the Army, General DeWitt, said, well, I don't know who's going to do what, but there have been 750 examples of people signaling to submarines offshore, and there's been sabotage, and so we're going to play it safe. And Roosevelt agreed. And then one person brought a case. Actually, there were 4 or 5, but the famous case is Fred Korematsu. And Korematsu brought his case against the advice of his family, against the advice of many who were in the camps who were saying, don't rock the boat. He's a feisty guy. I met him once. And he brought the case. And he got to the Supreme Court in 1944. No risk of invasion in 1944. Moreover, 2 lawyers in the Justice Department, Ennis and Burling, had gotten suspicious of this thing about signaling and sabotage, and they got the FCC to look up all this signaling, and they came in 2 weeks later from the FCC with a big report stacked up like that. There was no signaling. They said these were buck privates not knowing how to work the equipment. And there was none. And as for sabotage, no, not an instance, not one. J. Edgar Hoover led the charge against the internment. As J. Edgar Hoover said, you know, you don't have to intern these people. The FBI can deal with it. Well, interesting. And the court knew that. I've looked into it enough to think that that was sort of pointed out because they wrote a footnote that ended up being very obscure, but Charlie Horsky, a great lawyer representing the Japanese, pointed it out to the court, that footnote, in the Justice Department brief and said, read it. And I'm pretty sure they knew, but 6-3, they upheld it. They upheld the internment. So I've asked myself, why? This was Black and Douglas and Frankfurter and people who were in the majority, and I mean everybody was, but they were big advocates in Brown, and they were civil libertarians. Why? And the only answer I can give myself is, well, because they're thinking somebody has to run this war. Either Roosevelt runs it or we run it. And we know we can't, and therefore Roosevelt will. And that decision that they wrote with 3 dissents has been very much criticized. I think it was wrong. Virtually anyone who reads it thinks it was wrong. And wrong at the time, 1944. But wait, what are we supposed to do? And what I've tried to put in to show you an example of the dilemma and a possible way, I mean the 4 Guantanamo cases. We've had 4 cases come out of Guantanamo. In every one of those cases, the detainee was not a popular person. I mean, one was bin Laden's driver. I would say he is not the most popular person in the United States. But each of them is suing the President of the United States, the most powerful individual in the country, and in each case, the detainee won. The detainee won, including the court holding unconstitutional a law of Congress that said the detainees in Guantanamo could not get into court. We said that violates the provision of the Constitution that says Congress can suspend the writ of habeas corpus only in time of insurrection or rebellion. Now, nobody's totally satisfied. I was in the majority there. And nobody's totally satisfied with those opinions. On the one hand, people say, you've interfered too much with the power of the President to make certain this is not a suicide pact. On the other hand, The civil libertarians often say, this is too vague. You focus just on Guantanamo. We want more specific rules. We want to know exactly what has to be protected here, and you haven't protected enough. Well, I say, I'm sure they're all right. I'm not actually. I don't know. And what you do if you read that and see the dilemma in front of us, and I think you do that, I hope you come to the court, you'll see people who are certainly fallible, struggling with a very difficult question, and not deciding more than they have to, because no one wants to stop the president from being able to protect the country, and at the same time, no one writes what Sandra O'Connor, no one wants what she said in that one of those opinions, we can't write the president a blank check. That isn't, we can't, the Constitution can't, you see? And so, look at those, you have to make up your minds, because it's going to be history that'll say whether we're right or whether we're wrong. But sometimes it's a tiny step at a time as we're faced with very conflicting basic obligations, because it's right against right. And what I'm trying to do in that case, like the others that I write about, is to just give you a little picture of what's going on in the minds of the judges as they try to decide. All right, there we are. You see? What I've tried to do is tell people, and I do in 5 pages, I can describe our procedures, I do that. But I want the man or the woman who's going into the supermarket to see. I want them to see what it is we do and why it might be worthwhile supporting an institution that will decide things that are unpopular and that may well be wrong. You see? Because the greatest thrill for me, which is still there, after 17 years, is I look out at that courtroom and I see people of every race, every religion, every point of view, and if we have 300 million Americans, we have 900 million points of view. I mean, and they're felt strongly. Every race, every religion, every point of view, committed to the proposition that they will, in fact, decide their differences in a courtroom, under the law, and not in the streets with bricks and stones and guns. And that, I say, is the national treasure. That's what I want taught. That's why I want civics back. That's what I want those next generations to know. And I can only write about the court because that's what I know. So that's what I've tried to do. Thank you.
The justice has kindly agreed to take some questions. Samaya and Michael have, they each will come to you. Who would like to ask a question? We'll start with you, sir. Samaya, if you could bring the mic over to that gentleman. And please speak into the mic. Thank you.
All right, thank you. Thank you for coming here and sharing your philosophy. I have a question about pragmatism, and I don't want to boil it down to the one word because I know you probably wouldn't do that. But it's a two-part question. Can pragmatism avoid variable justice, and is that even a desirable result?
A variable justice, if you mean treating similar cases differently, is an undesirable result. What you want is to treat like cases alike, but it's often very hard to say what's alike. And therefore you have principles, if you're a law student or if you're a lawyer, you understand perfectly well the difference between law and equity. I mean, equity is a big force in the law because you not only have to treat like cases alike, you have to treat different cases differently. That isn't always easy to figure out. But of course, the object of the pragmatic approach is not just take that word. That's why I buried it with many other words. And I think when you look at law, I mean, I've been in this a long time, and you go to law school because it's not brain surgery, but it isn't just do whatever you want either, I guarantee that. And there are whole big systems that you have to learn, and I met a prosecutor earlier, I sometimes think his job is like being a brain surgeon. So is a defense attorney. It's tough, because it's very complex. And you're working with these very complex systems, and you're trying in these open areas, I think, to say, which is going to work out better? From my point of view, no. from the point of view of the document.
Let's take a question from over there. A question over there. That lady right there, please.
I think you were involved in the sentencing guidelines that came out.
Yes,
in
I
here.
was. I shouldn't
And that
make a-
prior
yeah.
question reminded me of that. Do you feel overall that they are successful, and did judges lose their ability to use the discretion that maybe we wish some of them had back again?
Hard to say. The sentencing guidelines were, quote, a reform. And before these federal guidelines had come about, most students of the subject thought we've gone way too far in the direction of the different cases differently. And in California, there was something called the California Adult Authority, and they would sentence people to prison, and then it would be an indeterminate sentence, and then eventually a parole board or something like that was supposed to let them out when they were, quote, cured, end quote. And in many instances, vast numbers, they weren't let out at all, or many years. So people thought that was a failure. So they said, the next thing we'll try is those guidelines. And the guidelines will try to treat similar cases similarly and say to the judge, Judge, if you have a typical case, follow the guideline. And if you don't, depart. Well, that's easier said than done, and when I'd go and talk about them, as I did because I was on the commission, they were about as popular among the judiciary as cholera. You see, because every judge thinks he knows the answer. If he sentences this person to 10 months, he thinks it's 10 months. Otherwise, why would he choose 10 months? I mean, nobody would. All right, but the problem is there's somebody in a different place, same person, 10 years. All right, so try to develop a system which says you have a typical case, this is your guideline. You have an atypical case, depart, and it will be reviewed in the Court of Appeals. Great in principle. It's taken many years to put these into practice, and they're filled with problems. And Congress, in the meantime, has come along, had mandatory minimum sentences. Everybody has to go to jail for a certain time. You'll get a case that doesn't warrant it, and you can't depart. But anyway, I probably said enough to show you I'm uncertain. I'm still an optimist. I think the great thing about the guidelines is it should focus the attention of the judges and the system, not so much upon are you guilty or innocent. That, of course, is important. But vast numbers of people plead guilty. And what about those people? And the question is, what do you do with that person? What should happen to that person? And orienting the system in that direction, I think, is a plus. And my hope is, still it's a hope, that eventually this will work out. And it doesn't, well, Justice Scalia's joke about the bear is applicable here too.
We have a question over there.
I'd like to ask you about the health care, the constitutional, but you can't comment on that. So let me ask you about one case that has been decided, and that's the one where parts of the campaign finance reform bill were thrown out and corporations got the right to give as much money as they want to fund campaigns. Can you tell me something about the thinking?
It's actually an interesting case to ask about. I was in the dissent. I was among the 4, and John Stevens wrote a very strong dissent. But I want people to say, and I don't want to be too convincing on the other side, I want you to see there is an argument the other way too. And it's really this, it says Congress shall make no law abridging the freedom of speech. And the people who were in the majority have always thought that the campaign finance regulation in general abridges the freedom of speech. And the argument, which is a perfectly sound argument, except I don't think it's right. But I mean, it's close. The argument is just simply this, that you say, well, money isn't speech. Of course money isn't speech. But you try running a campaign without money. You say? He says there are people who want to express themselves, they want to give money. You say, well, what about this really rich person? You say, once you get into the business, said Learned Hand, one of our greatest judges, once you get into the business of saying you're going to say this person has less speech so we can give the other person more speech, you've started down a slippery slope that has no end. And moreover, the members of Congress or others are experts at writing very complicated things that in fact write themselves into office. So beware. All right? That's the theme. It's not a terrible argument. I believed and joined the opinion that said that you can sometimes limit the vast amounts of money that some people can give so they don't drown out the people who have just as strong views. But you see the point there. It's two arguments that aren't, and of course I think I was on the right side, and I don't think they should have started the thing with corporations. But nonetheless, the best way is you read the opinions, you'll see it's complicated, you see we have difficult questions, and not surprisingly, I tend to think when I dissent that the dissent is completely right.
Let's take a question on this side. This lady, right? Oh, is there somebody there already? Excuse me. I'll get back to you, I promise.
I understand your point is that the power of law or the power of the court is proportional to the support that people give to the process rather than the outcome of the law.
Yes.
Now, as I see today, we are disintegrating in a sense of a support of the process, and we're looking at a politicized court, or we're giving a politicized view of the court, which I guess would be reducing the influence or power of the court. And in this time and trouble, I guess I'm asking you then to project what you see today into the oncoming future of this divided government.
Yeah, that's truly two questions, and I think they're both interesting, particularly because historically we'd have to go to the historians. The court's never been popular. Very rarely. Think of all those signs I can see from those impeach Earl Warren signs. I mean, I don't know if it's less popular now than it's ever been. It inevitably will be unpopular. That doesn't mean people will not, when the chips are down, go and follow the approach that the court said is necessary. So we don't know quite where we are if you look back in the whole scheme of things in the country. But of course there's something to be concerned about, and that's why I think that civics is so important. Now you raised another question that's very interesting, because it was very hard for you. See, first you said, well, it's so politicized, and then you said, I mean, it's said to be politicized. And so then you're wavering between, to what extent is it politicized? And I was just talking to a friend of mine, Judge Posner in the Seventh Circuit, how to put this. So if you say, well, the court's deciding things really in a political way, many of us have had some contact with politics, and real politics is who's popular. Are you a Democrat or a Republican? Where are the votes? And that's not in the court. It just isn't. I mean, it just isn't. I haven't really seen that. You say, well, what about Bush v. Gore? I think if I had enough time, I could convince you that not even there. All right? Now, well, what is it? So maybe it's ideology. Ideology. Are you a Adam Smith free enterpriser? Or are you a Marxist troublemaker? I mean, what are you? What's your ideology? What do you think is good in general? Well, I can't say never, but I'd say if I catch myself trying to think in ideological terms, I know that's wrong. But there is a third thing, and I don't know the words for it. But I did grow up in San Francisco in the 50s. I went to Lowell High School, a public high school. I've went to university out here. I went to Stanford. I've had the life I've had. I've worked in law for a long time. And all of us have that. You have it, I have it. We grow up, we have a job, we begin to get experience, and we begin to have views, not rigid necessarily, but what's the country like? What are people like in the United States of America? How does law relate to their lives? What's law like? How can this thing work out? And you can put it in that very general, abstract way and call it at times it's what we predict will happen if you do that. Sometimes we call it differences of value, or these are our values, or sometimes you call it general philosophy. We all have that. And we can't jump out of our own skin. And moreover, you shouldn't. And will that influence you when you have these really open questions? I'm sure it will. I'm sure it will. You can try to tamp it down and try to be objective as possible, but you can't jump out of your own skin. So when I went to the court, as I say, I grew up here, and then I went east for my sins, and I was there for a long time. Massachusetts, that's not the bastion of the Tea Party, whatever, but or maybe it is, I don't know. But nonetheless, I'd seen differences. But when I got to the Supreme Court, I said, my God, there really are differences. Really are differences. And after a while, I began to think, genuinely, that that isn't such a bad thing. I mean, it's a big country. I mean, why? Presidents will appoint different people to the court. A president who thinks he's going to get a judge that's going to decide every question his way is really making a mistake. Teddy Roosevelt appointed Oliver Wendell Holmes. Within a few months, he dissented Northern Securities, big antitrust case, and Roosevelt thought the opposite. He said, I could carve a judge with more backbone out of a banana. Right? So presidents will make, they can't count on that. But maybe at a very general level of a view of the law, or what's law like, or what's the country like, etc., they'll have more success. Not complete success by any means, but they'll get someone who has these sort of values in these very generalized area. The meaning of that is, because we're there for a long time. Jefferson said that. He said the problem with the court is that they never retire and they very rarely die. He said, but that means that over time, you may get people who in some of these open questions are starting with somewhat different places, or have different views about how black letter clear a rule should be, or whether it can be a bit fudged or a little bit messy, at that kind of level. So I think that's a good thing. We're 308 million people. We think a lot of different things. And it is not a terrible thing that in the Supreme Court of the United States, you have people that come from somewhat different places. So there we are. That's a more complete answer to your question. But that latter is the experience I have.
Justice, seems to me that one source of the tension and conflict that divides the country are viewpoints that emphasize different elements. For example, the 10th Amendment of the Constitution, which appears to emphasize states' rights as opposed to an oppressive federal government, versus the viewpoint that emphasizes the Commerce Clause and equal protection of the 14th Amendment. Could you discuss how the court has analyzed and debated these issues?
Because one of those, is a fabulous example for teaching purposes. The first one you mentioned, the 10th Amendment, fabulous example. And I wish people could have seen, Arkansas had a term limit rule on its members of Congress. And the question was, is the rule, maybe it was 6 terms or something, that they cannot serve more than 6 terms, is that constitutional? What a case. Why? Well, because you read the Constitution, and it says, you have to be in Congress 25 years old, a citizen of the United States, and a citizen of the state that you're being elected from. Well, are those the only things, does it mean? You can't have any other requirements? Or could the state have a few others too? Well, it's pretty hard to figure out. Because if you look at what they said at the time, you will see Hamilton and Madison thought that's exclusive, just those 3, nothing more. Jefferson and Story thought the opposite. You could have more. You say, well, what were they doing at that time? There was only one state that had more. Virginia. It had a property requirement. You say, well, they certainly wouldn't want a property requirement. Oh, okay. What about a requirement that you can't be mentally ill? See, you can think of it both ways. What about precedent? What about precedent? Oh, precedent the one way, almost perfectly balanced precedent the other way. So I just wish people could have seen that argument. You would have seen 9 people just struggling to find the answer to this. And I think, this is my opinion, that ultimately you have the 10th Amendment and you think it says power is not given to the federal government, reserved to the states. And some people put a little bit more weight on that. And they said Arkansas can do it. And other people, it was 5-4, I was in the majority. Other people said, but Congress is a federal institution created in Article 1, and you start mucking around with that, I mean, you don't know what's going to happen. The staff may get the power, there are a lot of arguments well known on that, and this should be up to Congress what the qualifications are of anyone. They seat their own members, not up to the individual states. And some people put more weight on that consideration. You see? So in the real cases, these kinds of things are pretty evenly balanced, very often, and then you try to work it out. Yes?
No, we've got.
Oh, all right.
Yes.
Yes, I'm just I'm just wondering, in view of the importance of the First Amendment, what in the world could have been the legal arguments or the legal justification for the characterization or categorization of free speech zones?
Free speech, I'm not sure what you're thinking of there. I'm not bringing to mind exactly what cases those words appeared in. What your question says, it may be that in certain areas, like obscenity or something, it doesn't have protection, or. I don't know what that is. That's probably a political matter. We haven't had a case on that.
One over there.
Yeah.
I was wondering what the Supreme Court's feeling was regarding term limits and direct democracy.
Well, I've told you basically the case. That's the case we've had. And there's nothing, I can't think of anything further than that. That was the case, and it was a tough one, and you get a good view of reading it, yeah.
Hi. I had a question about the newly passed Health Care Act and whether you believe that Congress, under the Commerce Clause, has the power to have an...
If I answer that question, I'll be impeached. But what's interesting about that, which I said when I was at the confirmation hearing, it's absolutely true. It's not just that judges are not supposed to talk about cases that come up because it's sort of unethical, etc. It's that it's really true that what an individual, me for example, is likely to say at a cocktail party, or likely to say when asked a question cold, can often be very different from what you think, when in fact you spent several days or weeks reading all the briefs in a case, getting to the bottom of it, discussing it, and spending quite a long time writing an opinion. So don't go start committing yourself to something before you've actually seen what the arguments are. And that's why, but yeah, that's why I can't answer it.
Thank you, Your Honor, for coming out. As I look out in the audience, I see very few young people.
Oh.
Fortunately, I have a 10, 15-year-old.
Yeah, there are a lot of young people. I don't know what.
Okay, raise your hand. Where are the young people?
Yes, everyone. I will.
No. I'm talking children.
I understand. Sorry.
And you alluded earlier,
yeah.
And I think the biggest threat to our republic is the lack of, the teaching that you alluded to.
Yeah.
How do we reach the young people? Because I consider it an honor to be here tonight, and as one of 9 that makes decisions for over 300 million people, it's like a government star that you are. And this is where children should be, to see that you're real. The government isn't just something that's static, that it's real people.
Yeah.
What is your approach to reaching more young people?
Well, I talk when I can. And what I say to the Bar Association, I said in Toronto, I said, look, this isn't my job any more than it is yours. Of course you're right. Of course we need civics. Yeah, you see the point. So what I say to the lawyers, hey, tell people what you do. And you feel strongly about it, tell some other people. And when there's law day or some other excuse, talk to the people in the high schools. And I love talking to the law school students, to the high school students. And what I'll usually say is I say, because they're interested in, well, what are they? They get interested in this. But I'm saying, really, I'm trying to say something about your life. I can't tell you how to lead your life. I can't. I can hope for you. I can hope that, you'll have a loving relation, you'll have a family, you'll have a job, you'll I hope, participate in the life of your community. And I can't tell you to do it, but I can tell you this, because I do have some expertise here, that the people who wrote this document thought you would participate. And I can tell you this, in my opinion, if you don't participate, and it could be on a library board, it could be on a board of education, it could be out teaching children how to read, it could be participating in political life. But if you don't, this isn't going to work. I can tell you that much. And of course, what I'm hoping to do is get them interested. And Sandra O'Connor has a big program called iCivics coming over the internet, which she hopes goes into classrooms. And the Annenberg Foundation, very nearby here, has done a lot of good things. They're in 55,000 classrooms. And of course, it's something I can't do, but it's something we all can do, and that's what we're involved in.
Two more questions, one over there.
We were very concerned today to hear that Justice Ginsburg had to evacuate a plane on a slide. We're hoping, I wanted to ask you how her health is, and also secondly, did all the justices read Jeff Toomey's The Nine book?
I don't know if they all did. I did read it, I admit. And Justice Ginsburg, I saw in that little news thing, it said she was okay, fine, and I think I probably would know if she weren't. And her health generally is fine. She's a more remarkable person, and we're good friends. Great. Yes?
And the last question is back there.
My question is about the post-World War II court and the pre-Warren court. How do you explain the more liberal decisions like Sweet versus Painter and Shelley versus Kramer?
Oh, there was a lot of them, I think, from what I've read. And here you're really, historians will know more. But there was a calculated strategy on the part of the NAACP to bring these cases gradually up to the court. And they thought if we start with a law school, every member of that court is going to understand that when one black law student is supposed to sit in a special place and can't talk to anybody else in the school, they're going to understand that that's not an equal education, because they've been through law school and they know what it takes. So this was a great strategy. So read there's a very good a one-man play I've seen on the life of Thurgood Marshall, and it is a good play, and it really encapsulates in an hour or two what was going on there. I mean, this was very much thought through and debated and discussed, and eventually they won.
Thank you, Justice Breyer. Thank you, everybody. Thank you, sir. Beautifully done.